Welcome everyone to this London Arbitration Week event hosted by One Essex Court. I am Alexander Brown, KC, a silk at One Essex. This session is entitled What Tribunals Really Need from Counsel and What They Don't. I'm joined by three of my colleagues from One Essex who I will ask to introduce themselves.
Sabrina, Nanchahal, junior barrister at Essex Court.
And I'm Charlie Graham, a silk at One Essex.
It sounds like University Challenge, doesn't it? I'm Liz Gloster, I'm an arbitrator, and I was a commercial court judge and in the Court of Appeal.
Thank you. We are going to talk about an aspect, each going to talk about an aspect of advocacy in international arbitration. Sabrina will start by addressing written advocacy. I will then talk about oral advocacy. Charlie will deal with cross-examination, and then Liz will speak about what the tribunals find persuasive. We'll then have a brief panel discussion, and then finally open up to the floor for questions. So without further ado, I will pass over to Sabrina.
I'm going to be talking about written advocacy, by which any written submissions being made to the tribunal, whether that is pleadings and memorials, setting up your case at the beginning of the arbitration, procedural applications, or pre or post-hearing briefs. I have four main points that I intend to address on this topic today. The first is that written submissions should be fundamental. The second is written submissions should be clear. Third, should be credible. And finally, should be user-friendly. Turning then to my first point, in arbitration, in contrast to litigation, there's generally no expectation that you'll be able to address your whole case properly. And in practice, there often isn't any time to do so. Your written submissions therefore bear the burden really of setting out your whole case, both on the facts and the law. But it is also your chance to ensure that you deal with not only your own case, but also the case of the other side. It means you can deal with the case as you see fit and put it in the best possible light, without any interruption from the arbitrators or perhaps the other side. It also means that if you run out of time, you're able to simply refer the tribunal to your submissions. You can be confident that you have managed to address the points that need to be addressed. And it also means that you can then focus on the most important points during the hearing, rather than feeling to address every single point that is part of your case. What I don't mean by that is taking any conceivable point. That is a matter of judgment, and I will come back to credibility in terms of deciding what points are worth putting before the tribunal. It also doesn't mean repeating every single point of every submission in the same way. For example, by the time we get to a hearing, there will have been at least 2 rounds of written submissions from each side, setting out your case in about as much detail as is possible. But hopefully by the time we get to the hearing, the issues will have narrowed or crystallized, and you might want to focus your energies on those issues at that point. So if you have pre-hearing briefs or skeleton argument, you will most likely be addressing the issues that really still exist at that time, rather than running through a chronological account of your case, which you might have done in your pleadings. My second point is that the most effective written submissions are clear and easy to follow. That starts with being clear as to what it is you're asking the tribunal to find. So you then want to set out how the tribunal should get there in the simplest possible terms. The subject matter of international arbitration is often difficult and complex and involves a large body of evidence, whether that's contemporaneous documents, witness statements, and expert evidence across multiple disciplines. You want to think of your written submission as a roadmap or a guide through the morass of information. You want to explain how and why any of this is even relevant, and how the different parts fit together It's not simply a case of regurgitating all the evidence that is already there. The tribunal can read that themselves. In the same vein, don't be afraid to use appendices, schedules, tables, and diagrams. To misuse the expression, sometimes a table or diagram is worth 1,000 words. In other cases, the detailed factual analysis or account and chronology are of course relevant, but might obscure or interrupt the flow of your argument. It might then be better to include it as an appendix for the tribunal to peruse at the revision. And while we're on this point, this is more of a pet peeve than anything else. If you are the claimant, be clear as to the relief that you are seeking. There is nothing wrong with putting a catch-all, whatever further relief might be found relevant or appropriate. But you want to be clear on what you ask the tribunal to find from the outset. My third point is credibility. Ultimately, your role is to persuade an intelligent and experienced tribunal to accept your case over that of your opponent, who is trying to do the exact same thing. And to do so, you need to build trust in the tribunal so that it will take your position and hopefully accept it. There are usually multiple rounds of written submissions before the parties ever get in front of our tribunal, whether in person or virtually. So the first impression is made on papers. And sometimes, where there are post-hearing submissions, it's also often the last chance for you to make an impression of the tribunal. It's therefore particularly important to establish credibility in your written submissions. So how does one go about establishing and maintaining credibility? Well, my first point is on tone. Highly emotive or descriptive language will rarely advance your case. And in most cases, detracts from it. It's much more effective to explain to the tribunal why you are correct and the other side is wrong than to tell the tribunal that that is the case. If something is obviously without merit, manifestly untrue, then you should be able to say that in 1 or 2 sentences. Overuse of language or hyperbole may also lead the tribunal to lose confidence in you, particularly if they see an example where they just disagree that it is in fact manifestly untrue or obviously the case. So save the adverbs for cases where they are in fact apt. And by doing so, you will also highlight those instances where it is in fact the case that the position has been overstated or otherwise. Your role is to persuade the tribunal that your conclusions on the law and the facts, or the way the facts apply to the law, is correct. That starts with setting out the end position you want to get the tribunal to get to, but you must also explain then how and why you get there. You want the tribunal to follow your thought process and hopefully agree with it, or at least find it more compelling than the position put forward by the other side. Deploy the evidence. Ultimately, we all know the case is only as good as the facts that you have before you. But written submissions allow you to situate the facts in the case and to present them in the most favourable way. And sometimes there is no better way of demonstrating a point than what the contemporaneous documents say. So quote them rather than spending a paragraph explaining them. We obviously all like to think there are no weaknesses in our case, but I'm yet to come across ones where there aren't. Ignoring weak points doesn't make them go away. You can counter them being picked up by the other side, or perhaps worse, by the tribunal at the hearing. Dealing with these points in the written submissions means you have a committed response to them that you can refer to if you need to be. And finally, if you can, do not make bad points, or be willing to concede them where possible. Advancing and maintaining a bad point will undermine your other submissions. I would put it this way: it's better to have 2 good, credible points than 4 points, 2 of which are hardly arguable. Turning then to my fourth and last point, written submissions should be user-friendly. You want the tribunal to use your submissions, whether it is when you're reading into the case, during the hearing or when it comes to writing its award. So try to make it as easy as possible for the tribunal to navigate through your submissions. I've set out a few examples here, and I'm the first to admit they're not groundbreaking or complicated, but I do find them quite useful. One is including a table of contents. It's particularly helpful where you have lengthy submissions, memorials, they'll run into hundreds of pages, to know where to turn to. It saves a lot of time. They also provide an overview of your case at a glance, which is another way for the tribunal to see where your submission is going. And for digital versions, it's worth including hyperlinked versions. Use headings and subheadings to signpost your submissions. They should be short and to the point. You want to know what it's addressing, but you don't need to set out your submissions in heading. That is what your submission is for. Numbered headings can be useful to situate yourself in the case. And finally, including bundle references. You've gone to the effort to set out your case, to put in the evidence, to read the evidence. You finally got the tribunal to read your submissions, and they've bothered to go and look at the documents. You want to make sure that they actually find them. Another example, which I haven't put here, but I just came across it yesterday, which made me think of it, is to limit internal cross-referencing. Where you do cross-refer, you want to identify the relevant point that you are making, and then include a specific cross-reference, not simply as I've set out above or as I've set out below. You don't want to send your tribunal on scavenger hunt to understand your case. That's all I have to say. So I'm going to Alex.
Thank you very much, Sabrina. There are some seats at the front, so please do feel free to come and sit down at the front. I'm now going to be talking about oral advocacy. So those parts of the hearing that you're making submissions directly to the tribunal, whether that be in applications, at a procedural hearing, or in opening or closing submission. And I have three main points that I will go through. First, oral advocacy should help the tribunal. Second, oral advocacy should use the written materials. And third, oral advocacy should be responsive to the tribunal. So jumping straight in with my first point, and really the most important. Oral advocacy should help the tribunal. The most effective oral advocacy is that which actually helps the tribunal understand what is an issue, understand what the parties' positions are, and helps them to decide the case, preferably in your favour. International arbitration often involves very lengthy pleadings or memorials or written openings. Sabrina has spoken about what constitutes effective written advocacy. But the reality is that in most arbitrations, there is a large body of written material already before the tribunal, before you come to any hearing. And the oral advocacy needs to help the tribunal see what the issues are and what really matters. It may be that there are 50 issues between the parties set out in detailed pleadings and memorials across several hundreds of pages. And you might have only half a day or a day in oral opening. You aren't going to use that time to go through the entire factual chronology from start to finish, addressing every minor point of difference between the parties. You simply don't have time. You need to focus in on the issues that really matter. Think about it this way. When the tribunal comes to write its award, it will very likely be structured by reference to specific issues. Tribunals typically don't decide cases by going through the chronology point by point. They focus on the big issues and their decisions on those issues. And whatever advocacy you're doing, it should generally be focused on those issues and structured by reference to those issues. Essentially, what you want to do is give the tribunal the headings for its award and then set out clearly what your submissions are under each of those headings. And those submissions should be in straightforward, clear language. Doesn't waste time dealing with ancillary or minor points, doesn't distract the tribunal from what it is being tasked with doing. And if you can truly help the tribunal navigate its way through a very complex dispute, then they're going to be very pleased with you, and your oral advocacy is going to be persuasive. Moving on, my second point. Effective oral advocacy uses the written materials that have already been submitted. And the important point there, the important word, is uses the written material. What that doesn't mean is just reading out or regurgitating your written materials. That's not helpful. That's not good oral advocacy. It's not going to persuade the tribunal. Most arbitrations, the tribunal is highly pre-read. They have your pleadings, they have your memorials, they have your written opening, and they can refer back to them at any time. So oral advocacy needs to bring something different to the table. An analogy I sometimes use is visiting a museum. The tribunal can see all of the exhibits already, the written submissions, the written evidence. Your oral advocacy is like a museum guide that takes you around and explains why specific exhibits matter and how they relate to each other, that tells a story. A good guide brings the exhibits to life in a way that simply staring at them cannot. That is what your oral advocacy has to do, bring your case to life. And you can't just ignore the written materials. The tribunal will have read them and will have them in mind. What your oral submissions need to do is use that knowledge and build on it. So you might have a contract dispute where your written case has set out a really detailed argument on contractual construction. You don't want to just read out that argument, but equally, you shouldn't just ignore it and act like the tribunal is coming to the dispute fresh for the very first time. You'll want to refer the tribunal to the relevant section in your written case, situate them in the materials. That will help the tribunal recall where your argument is set out and what, in broad strokes, the argument is. And having done that, having situated them, you can then develop the argument orally in a shorter, punchier way, using different language, different examples than those in the written case. And as Sabrina said, the written case has the burden of setting everything out. In the oral advocacy, you don't have that same burden. You can focus in on what really matters and the absolute best way of putting your case. You don't need to go through the entire story from start to finish. You can highlight what really matters in the lengthy narrative. And in doing so, you can sprinkle in the best references to the written evidence or submissions. Think about it this way. The goal is that the tribunal will end up, after the hearing, with your detailed written submissions, but then it will also have had a clear, concise summary of that case explained to them orally at the hearing. What that means is that if your written case has missed the mark, it's not persuaded the tribunal, your oral advocacy is essentially giving you a second bite of the cherry, a second way of explaining your case. You have two opportunities and you don't want to waste them by repeating the same material. And at the end of the hearing, the tribunal will have a transcript of the evidentiary hearing. And if you're just reading out portions of your written case, you aren't giving the tribunal anything else. You're wasting your time. So another point about the written materials is that you should give references in your oral advocacy to particular documents. But you don't need to go to every document and you don't need to read them all out. You need to exercise judgment as to what quotes, what key bits of the evidence you want to refer the tribunal to. And you often have a very limited time for oral advocacy, usually far less time than you would like. So you can just give the tribunal the references, which the tribunal can then go to in its own time if it wants. And again, have in mind what the transcript will look like at the end of the hearing. You want key quotes, key documents, key references sprinkled through your submissions so that a tribunal ends up with a useful transcript and follow the links back to the underlying materials. Another aspect of using the written materials is to address points made in your opponent's written case. As Sabrina has said, obviously your written case should have done that already, but the tribunal might not quite have pieced it all together. You have a 100-page defence which has gone through a statement of case on a paragraph by paragraph basis. The tribunal's seen lots of as to paragraph 77, as to paragraph 78. It may well have struggled to follow exactly what argument was being raised. What your oral advocacy can do is take the tribunal to your opponent's case and then specifically and directly respond to it in a clear and effective manner. So the tribunal absolutely understands what your opponent is saying, but more importantly, how you are dealing with that argument. My final point, a short one, is that effective oral advocacy must be responsive to the tribunal. You want a dialogue with the tribunal and not a monologue. Tribunals are often asked questions. And sometimes advocates see those questions as a difficulty, a problem, a challenge, something to deal with and move on. That is not the right attitude. The tribunal asks a question, it means they're interested in the issue and they want an answer. Advocates should address questions head on, not attempt to dodge them. Questions are an opportunity, something to welcome, something to be happy about, actually. The tribunal is giving you a clear indication that it's interested in this point and it needs some help. Maybe it doesn't understand it, maybe it's unpersuaded, maybe it just needs understanding of really what the issue is between the parties. So take your time to answer any questions posed by the tribunal. It may well result in some back and forth as you discuss and explore the issue with the tribunal. I had one in June where it was a short point that I thought I'd deal with in 10 minutes, but the tribunal was really interested. I ended up having a discussion for 45 minutes. But I didn't see that as a sort of waste of my time. I actually saw that as really helpful to fully explain and explore this issue with the tribunal. So I really welcome questions. I want questions. I want a dialogue with the tribunal, which obviously goes back to my first point, which is all about helping the tribunal. As is typical, I've run out of time. So I'm going to pass over to Charlie to talk about cross-examination.
Thank you. Thank you, Alex. Now, what I'm going to do in talking to you about cross-examination is give you 7 basic tips, which I'm going to run through quite quickly. If you let your eye fall down the list, you'll see they're all pretty basic points. But it's amazing how often advocates, even advocates in international arbitration, appear not to have learned them, or if they have, perhaps to have forgotten. So tip 1 is to identify your target concessions. Now, what do I mean by a target concession? It means looking at what that witness has already said in witness statements, what their client has said in what the party calling them has said in their case, and to work out in advance what concessions you want to get from that witness. So a target concession will usually be a concession by the witness that something in their witness statement is wrong or misleading, or they've omitted to mention some key fact. But equally, it could be a concession on an aspect of your opponent's case that the witness has studiously avoided dealing with in their written evidence. Now, my advice would be to rank the target concessions that you want from that witness in order of importance, given their place in your case or defence, and the other means available to you of establishing the true position. So there's no point battering a witness on a particular point if you think that that's unlikely to be as productive as taking the tribunal to 3 particularly strong documents. But organising your questioning by reference to target concessions is a critical skill. As other speakers have mentioned, it's particularly important in the arbitration context where time is almost always limited and closely controlled, and that includes time for cross-examination. If I go forward to the next tip, that is tip 2, know the documents. And I remember being told when starting out that there were three secrets to successful cross-examination. Know the documents, know the documents, and know the documents. That's because the real key to a successful cross-examination is to know the documents inside and as you can see from the second bullet there, by documents, I don't mean just the documents produced by either side, but the witness statements and the pleadings and memorials as well. That is because a detailed and thorough knowledge of the documents enables a cross-examiner gently and politely to dominate the witness. If a witness refuses to accept a proposition, the cross-examiner needs to be able to take them to a document or a short run of documents that suggests that the proposition the questioner is putting is correct. Again, if a witness suddenly changes course and introduces new evidence, never before mentioned in their written statement, the cross-examiner needs to be able to find very quickly which documents will best contradict or shut down that particular foray or line of attack. It's no good saying, oh, I'm going to come back to that later, Mr. Snoops. The moment they have gone. Very obvious one, tip 3, and again, it will have been drummed into you from the outset, I'm sure, but it's worth repeating. Use closed, not open questions. And the 2 bullet points there set out what one means by a closed and by an open question. And given this audience, I'm not going to read those out. But an open question gives a witness the opportunity to present their story in a way which supports the case of the party calling them, either by hiding a key point in a forest of detail or by rehearsing their party's strong points. It allows the witness to use up some of your valuable cross-examining time. Whereas a series of closed questions enables the cross-examiner to maneuver the witness to a key target concession and can make it look like a witness who fails to give a simple answer to the questions put. Makes it look as though that witness is being evasive or unhelpful. Tip 4, keep your questions short and simple. The shorter and simpler the question, the worse the witness is going to look if they fail to answer it properly. A long and rambling question enables the witness to respond to just part of it, or to say that they don't understand it. And a long and rambling question can leave both the witness and the tribunal confused. If the tribunal finds a question put to a witness hard to follow, it's going to sympathize with that witness. It might interrupt you and ask you to rephrase, by which time the witness knows what's coming and will have more time to think about his or her answer. When the question is short and simple, the question and answer read much better on the transcript and are much more useful to you when you're preparing your post-hearing brief or oral closing submissions. Always bear in mind, when cross-examining, what the transcript will look like. Even if it makes your question slightly longer, it is often better to read out the key wording of a document so that the tribunal, when reading the transcript later, immediately understands the impact of the exchange. Tip 5, to prepare a detailed plan. It is essential to have a plan for the cross-examination of each witness. And the plan should set out which target concessions you're aiming to extract from them, how and in what order. The more skeletal the note you make, the more flexible you can be when putting your questions. But a script setting out questions in full may be very helpful in a tricky area where the phrasing of the questions has to be exactly right. So there is no right and wrong in your detailed plan between having all your questions set out in full, which can tend to reduce maneuverability, and having such a skeletal series of notes that if you reach a bump in the road, the way you phrase your question may not be exactly right. That said, always be prepared to abandon your notes and to go off-piste, if I can put it that way, if you need to. It is impossible to foresee every answer which a witness might give. And again, going back to tip 2, the better you know the documents, the better your off-piste cross-examination will be. In preparation for a trial, you should constantly be revising your cross-examination plan to take account of developments in the case. Where one witness has given you the concession you need during the course of a hearing, don't go back to the same issue with that witness or with any other witness. That concession might, in subsequent questioning, be withdrawn or in some way unraveled. And you should also, when you've got your plan, cross-reference it, either with electronic wizardry or with good old-fashioned post-it notes, so you can easily find your way around your detailed plan. So if a witness suddenly says something and you realize you need to go to the section on the meeting of the 25th of January, you can find it and you're not left going through a large quantity of detailed notes to work out where your notes on the 25th of January meeting were. And it's also very important for this detailed plan to be developed first with an acknowledgement of what time you've got. And you should be able to know how long, on average, it takes you to put questions to a witness. So you know if you've only got an hour with witness P, that you know what you've got to cover with that witness. You don't want to find that your hour is up and you haven't covered 3 of the 4 target concessions you wanted to make. If you've only got limited time with a particular witness, it's obvious, but you must make sure that you deal with the most important areas, the most important concessions you want to get from that witness up front. Now, keeping the tribunal on side when you're cross-examining, again, you've got to have this relationship with the tribunal and to work out what is going to appeal and what is not going to appeal. Many tribunals are, as the first bullet point says, instinctively hostile to aggressive cross-examination. And generally speaking, it is a mistake to be aggressive with a witness, unless and until the witness's answers and conduct mean that you will have the tribunal's support in stepping up the pressure on that witness. And remember, going back to tip 4, short and simple questions keep the tribunal on side. Much better to come across as patient and inquisitive and as asking politely the very questions the tribunal thinks to itself it wants answered. A friendly and engaging cross-examination often achieves much more and in less time. It is likely to appeal to many tribunals somehow, and sometimes it is not an option, and you have to be aggressive. But allow and encourage the tribunal to put its own questions to the witness. Scrutinize the tribunal's questions just as you might when your question, as Alex is explaining, during your own oral advocacy. If the tribunal has a question for a witness, that will be a very useful pointer to the tribunal's priorities. And it may reveal a misunderstanding on the tribunal's part, which you can then seek to address in remaining cross. Second slide there, I think, is self-explanatory. Look at those 2 points. If the tribunal's being impatient say because you're laying the groundwork for a bombshell question that is perhaps just around the corner, hold your ground and very politely ask the tribunal to bear with you. But if you haven't got that sort of point just round the corner and the tribunal has intervened, then drop that point with the current witness and see if the same point cannot be covered with a later witness, by which time the tribunal may have a clearer idea of the target concession that you're aiming to achieve from one witness or another. Dealing with experts, much the same as dealing with factual witnesses. Note the second bullet point there, be respectful to expert witnesses, particularly important not to be aggressive towards an expert witness unless the time and the circumstances demand it. And obviously that can be if it becomes very obvious that the expert witness is what is sometimes referred to as a hired gun, or then you can take your gloves off and deal with them that much more roughly. Always when cross-examining experts, look for the key factual experts that an expert is making or has been asked to make, and ask the expert what the impact of changing their assumptions will be on their conclusions. Second slide here, how to deal with experts, very obvious. Work closely with your own expert in order to prepare your cross. So, in conclusion, 5 bullet points to cover 7 tips. Preparation is key. Start with your target concessions that you want from each witness. Prepare by being thoroughly on top of the documents. Prepare your questions, keep them short, keep them closed, organize your questions into topics that the purpose of which is to reach a target concession. Keep control of the cross-examining process by dominating. And this is best done by being knowledgeable, focused, and polite. And watch the members of the tribunal all the time. Are they following? Are they interested? If they are, great. If not, it may be best to move on. That was all I wanted to say before handing over the metaphorical battle on to Dame Elizabeth.
Thank you. Well, good morning. I have to be really careful here, for some of you have appeared in front of me in arbitrations and indeed in court. So I don't want to upset you, because the last thing an arbitrator wants to do is to upset its potential clients. Sorry, his or her potential clients. You'll see, first of all, that I don't have any slides apart from the one with my name, which is quite sensible. Why don't I have slides? Not just because I haven't had time to prepare any, which is the truth, but also because sometimes I hate slides as an arbitrator. They can distance the speaker, counsel, from you. They can distract from oral argument, and then they can cram far too much information into the bit of the page. Often they can misstate the picture, and worst of all, sometimes you get slides with pictures on. Apart from the fact they're patronising in many cases, because where the process, whether it's an LNG plant or whether it's an oil well, can be very, very patronising, because you know how the thing works. You read the expert reports with all their diagrams. Sometimes slides can be useful, and I love them. When is that? When they give you the figures or the arithmetic if you're doing a pricing arbitration, or the quantum if it's really heavy on damages. When they give you the figures, they're on the page. Someone else has done the arithmetic for you on the different scenarios. That's when I love a slide. But a practical point, make sure that although you deliver them electronically, the tribunal has got something to take away in her or his grubby little hand. Usually spiral bound is good. Really practical point. Make sure they've got them. I have got so many bundles of papers with a bit of a handout here, a bit of a slide there. Make sure your tribunal takes them away with you. And I think my final point on slides, because I've had so many unnecessary rounds about these, make sure you agree with the other side as to when you're going to hand them over. At the last minute, out of the hat, no, they should be handed over beforehand. Written submissions. Well, you've really heard it all, haven't you? My practical point to you is the tribunal will want to copy and paste or cut and paste from your written submissions. Make sure, and indeed agree in advance with the tribunal, how they're going to look, how easy they're going to be to copy. Because I can tell you some of my more frustrating moments is when I haven't been able to change a PDF into Word, and it seems it's a bit late in the day to ask counsel to do that for you. And also, you don't want so predictive numbering that the poor tribunal who's writing the award can't copy and paste. Sorry, these are really basic points, but they're what I hate and what I love. Oral submissions. You've already been told not to carry on a monologue, carry on a dialogue with your tribunal. I hate counsel who says, oh, well, that's a very interesting question, but perhaps I can come back to it on day 3 of the hearing. Oral advocacy is all about the here and now. Enjoy the questions that your tribunal puts to you. Okay, have a shorter adjournment, but do feel in a position, if you can, to answer them. Number of people. I know it's a really good idea to let junior advocates have a go, whether taking witnesses in chief, whether cross-examining minor witnesses. But sometimes for the tribunal, it can be really off-putting if you've got 5 people making closing submissions. I've had that where there's meant to be a lead counsel because somebody's got to have an overall plan, and that's useful. But if you hear 3 or 4 submissions from different counsel, you sometimes lose the thread, or they lose the thread. And there doesn't seem to be a master plan. And even if they say, well, advocate 1's going to be dealing with liability on this, advocate 2, she's going to be doing liability on that, advocate 3 is going to be dealing with quantum, advocate 4 is going to be dealing with causation. Inevitably, it can be quite difficult. Sometimes it's really good where you split liability and quantum, for example, but sometimes it can get very muddling because the counsel who's raising a particular point actually is taking you back into a previous issue which you want to ask the question about. So plan that really carefully. Another bugbear of mine is constant objecting by counsel. I object to that comment you've made and I want to reserve my position. I object to what the other side say and I want to reserve my position. We know that. We don't have to be told that every single time. You get a comment from the other side you don't like, or you get some comment from the arbitrator. Obviously, sometimes you've got to do it where you think a really bad point has been made or where you've had a really bad decision against you. Then do it, but don't do it kind of every half an hour. Cross-examination. Again, you've been told it all by Charlie, but I come straight from the hot seat. This time last week, I was being cross-examined in New York as an expert witness on a deposition. So I know it all from the wrong side of the table. Do not be sneery. Do not rubbish your witness. Okay, a tribunal hearing is not a social occasion. So you don't need to be palliating. You don't need to be charming. You don't need to ask about their journey over or anything like that. But you do need to be polite. You do need to look at your witness when you're cross-examining him or her. You do need, I think, to shake hands at the end of the session with everybody. You do need to be polite and courteous. I'm not saying you need to be seductive with a witness you're cross-examining, although I've seen that done by one member of my chambers doing a really good job so by the end, this woman, who was not an expert, but was a big player in a particular case, was eating out of the hand of the cross-examiner before he stuck the knife in. And that's what we want to achieve. It's it's killing the enemy in the most efficient manner possible and in the most cost-effective manner possible. And that can usually be best done by being charming and leading the witness to the pit before you throw him or her in. And another point that was made, I remember Charlie being in front of me when he was a QC and I was a judge, and unfortunately came second. But the barrister on the other side, who was cross-examining Charlie's witness, was so mean and so nasty that actually by the end I felt quite a bit of sympathy for Charlie's witness, who was quite a flamboyant character all of his own. I don't mean Charlie, I mean the witness. So that is really important. My last point, because I know we're running short of time, is this: co-arbitrators. Now, I know this session is about what counsel have got to do and not to do, but actually, as counsel or solicitors who are choosing arbitrators, please think of the dynamic of your tribunal. An arbitrator who is so procedurally minded, a chair who is so procedurally minded that he or she can't agree an extension of time or just how to decide a simple procedural application without issuing procedural order number 24. You really don't want to land your co-arbitrators, your party-appointed arbitrators, with somebody like that. So think about the dynamic of your tribunal. You don't want to have a pompous arbitrator who is chair, who is very dismissive, not only of counsel, but also of comments made by co-arbitrators. My wish would be that parties who appoint tribunals should leave the party appointing the co-arbitrators a little teeny bit of discretion when they come to appoint a chair, rather than applying a strike and rank procedure, which may land the co-arbitrators with somebody they might not find it easy to work with. I mean, I know we're all sweetness and light. I know international arbitrators are lovely, cheerful people, but sometimes the dynamic can be wrong. Sometimes it may be wiser just to leave a chair, party appointing arbitrators with a little bit of discretion as to who to choose, even though he or she might not have come top of the list. I think I've run out of time.
That's fine. Okay. Thank you very much, Liz. I'm genuinely pleased to hear Liz agree for the most part with what the three of us had to say. My nightmare was we all said something and you went, no, I don't find any of that persuasive. We're now going to move on and engage in a short panel discussion on what is a really key question. Tight time constraints in evidential hearings, a blessing or a curse. And essentially, what we're going to deal with is whether tribunals too often impose an overly compressed timetable for the main evidential hearing, leading to points not being properly developed or being decided only on paper after an exchange of written submissions. Or, on the other hand, whether demanding timetables imposed by tribunals are to be welcomed because they compel a discipline on the parties, encouraging them to concentrate on their best points. Charlie, I believe you have firm views on this.
Well, I do. But I'm going to start by saying it's a familiar scenario. Early on, perhaps at the first CMC in arbitral proceedings, the timetable for the proceedings is agreed by the parties or directed by the tribunal. And this is often done, indeed it's usually done, before the pleadings or memorials are complete. The documents setting out the scope and the content of the dispute at this stage may only be the claimant's request for arbitration and the respondent's response to that request. As the case develops, memorials or pleadings plus witness statements and expert reports may then make clear that the original time estimate for the main evidentiary hearing is woefully inadequate. Increasing the length of the main evidentiary hearing is usually impossible by that stage, because the members of the tribunal or the legal teams for one or more of the parties involved have diary commitments in the weeks or days following the period that's been reserved for the hearing. And rescheduling the main evidentiary hearing at a relatively late stage for a longer period at a later date tends to mean, in order to find a time slot that works from the point of view of all parties and the members of the tribunal, that the hearing has to be postponed for months and months, and introduces an unwelcome hiatus between the start of the oral hearing and its conclusion. One solution when this happens may be to, say, axe oral closing submissions if they've been provided for, leaving the parties to make their closing submissions only in the form of a written post-hearing brief. Another solution which tribunals quite often impose, or which the parties sometimes agree, is something I've touched on earlier in my remarks about cross-examination. It's a prescriptive timetable scheduling how long the cross-examination of each witness will last and precisely when that cross-examination will take place. And that can be helpful for witnesses. You can have Mr. Brown knows he's going to be cross-examined on the Wednesday afternoon, and Ms. Black knows she's going to be cross-examined on the following morning. Or a tribunal might agree to sit late on a particular day to allow the cross-examination to be completed, or might agree to sit early the following day, or both. But extended hearing days certainly are no magic bullet. When tribunals sit until 7 or 6 or 7 on a hearing day, assuming that their diaries allow this, or start at 8 or 9 a.m. the next day, the result tends to be that all participants, i.e. the tribunal members themselves and the legal teams, are burning the candle at both ends. That may not matter very much. What does matter is the impact of extended sitting days felt by those witnesses who are being cross-examined throughout such a day, who sometimes end up giving evidence when utterly exhausted, something that runs the risk of procedural unfairness, in my view, to one party or another. Despite such measures, there may simply be not enough time for the hearing to be completed within the time originally allowed. What can then happen is the parties end up agreeing that, in preference to having the hearing of the relevant factual and expert issues postponed for months, quantum, say, or some other discrete area of the case, then ends up being agreed or ordered to be dealt with on the papers. Obviously, this is only workable in certain cases and only with the agreement of the parties. And don't get me wrong, such an approach can work, but it too can give rise to procedural unfairness. The solution to the problems I've been trying to outline seem to me to lie in arbitral tribunals building in significantly more slack than typically they do now when fixing the length of the main evidential hearing in the first case. If parties and tribunals took the time at the outset of proceedings to build in a decent measure of slack for the period they think they will need for the main evidential hearing, that would minimize the sort of difficulties I've been referring to. And if the extra time is not needed, those extra days could be released once it was abundantly clear that they would not be needed. Or the members of the tribunal could use them for their deliberations, which would have the advantage of being deliberations immediately after the hearing, rather than, as sometimes happens, if members of the tribunal have to go on to hear another case immediately afterwards, they don't actually come back to think about your case for a number of weeks. Above all, the key thing to my mind is that parties and tribunals should not be unrealistic and overambitious when first fixing the length and the start of the main hearing. Too often, a desire to have the hearing held sooner rather than later results in a hearing being fixed which is simply too short, and that can lead to that very hearing being postponed relatively late in the day, or worse, proceeded with anyway, when everyone knows it's not long enough for the evidence that each side wants to fall to be properly tested, or for the issues that it will fall to the tribunal to decide and to have been properly explored before. So that is my take on this, and why I think the tight time constraints are very often a curse rather than a blessing. But I think, Liz, you have different views.
Well, not necessarily. It all slightly depends. I think a lot of time can be wasted in hearings. Do we really need 3-week hearings, 4-week hearings, which we might get under Charlie's view of the world? Certainly at first instance in the commercial court, we used to have hearings that went on for months with lots of parties. So yes, arbitrators are sitting in effect at first instance. In the Court of Appeal, on the other hand, you'd be very lucky if you got even a week's hearing. So it's a question of efficient use of time. And my view is that if you build in a lot of slack, actually money is wasted, days are wasted. And what is really important is from the get-go to have an informed decision as to how long the arbitration is going to take. And parties should know that even before the pleadings have been concluded. But if they haven't, then maybe there should be an initial fixing with a midstream conference, case management conference, to review the timetable. But that obviously involves, or usually involves, having a timetable that may well be too long. I'm a great supporter of bifurcation and flexibility, particularly of bifurcation between usually liability and then damages, because often where you've got a compressed hearing, you, the tribunal, have actually decided on liability, and you're then in the embarrassing position where you can't really say so because you've still got to receive post-hearing submissions in relation to liability and quantum. But you know in your own minds that whatever the parties say in relation to liability, you're never going to get to quantum. So often bifurcation can be a key. I think a lot of arbitrators are unwilling to direct bifurcation. A lot of parties seem to be unwilling. I don't quite get it. To me, it might well be more efficient. And I think my other problem that I have with arbitration as opposed to litigation in relation to timing and time constraints is this religious devotion to the chess clock and the splitting up of time. I think parties should be more brave to say to the tribunal, obviously one side will be saying, look, this isn't an appropriate case for 50-50 time allocation. This is a case where the real issues are being fought by the claimant or the respondent, as the case may be. And it's simply not appropriate to give the other side the equal time that we need. I've very, very rarely heard that argument in an arbitration. I've heard it lots of times in the commercial court. But I think you should direct your mind as to really whether you're going to have this slavish adherence. So those are my views. I think arbitrators do need to set aside time. But I think things can be done crisply and efficiently by an effective tribunal and by counsel who are up to speed. So maybe I don't share your generosity, Charlie.
If I can pick up on one point that Liz made about bifurcation, in practically all commercial arbitrations, there are issues which can determine the outcome. Maybe it's a liability quantum split, but perhaps it's a jurisdiction issue or a limitation issue. And if those issues are resolved a particular way, then the rest of the case falls away. So I do question why we spend months preparing evidence and submissions on parts of the case that might never arise. And on the topic of tight time constraints, why are we wasting valuable hearing time on those issues? And a key advantage of bifurcation is it allows the parties and the tribunal to focus on particular discrete issues and give them the time they deserve. What I will say is that bifurcation does usually require a degree of party cooperation to carefully identify the discrete issues that can and should be dealt with in each phase. And it's extremely important that the procedural order in bifurcation, carefully defines precisely what will be dealt with and when. There is nothing worse than confusion or misunderstanding as to exactly what is on the agenda. Sabrina, what are your thoughts on bifurcation?
I'm going to play devil's advocate on bifurcation. I think there's a real risk that bifurcation creates unnecessary delay and additional costs to parties. A separate phase means submissions, likely additional evidence, and of course a hearing at the end of it. Witnesses and experts might need to give evidence twice, and a significant delay, for example, between the liability and quantity phase, would lead to the parties, maybe less very unusual, to forget about what the dispute is really about, or certainly the details underlying it. Of course, all of those matters might vary vastly one party over the other. One party might get a resource and shoulder the burden of the additional costs or the delay in decision. In another case, a party that is held liable might very much prefer to have some distance between that finding and the kind of cold, hard facts quantum. I think, as Alex said, one has to be very careful in identifying discrete issues that are, in fact, suitable for a separate determination. Issues that might appear at first glance to be separate, certainly in legal terms, can in fact often overlap. I had in mind a case I did with Alex, where we resisted the determination of a limitation point as a preliminary issue, which, as a legal matter, in one sense, was entirely separate and could have decided the case either way relatively quickly. But in fact, relevant factual matters heavily overlap with those going to the merits of the case. The exact same factual witnesses would have been involved, and you would have had an artificial breaking point, essentially, between dealing with things that, with factual matters that happened after the underlying relevant issues that go to the merits of the case. You would have had a split witness statement dealing with two issues out of order, and that didn't necessarily make sense. And then, as Alex has said, cooperation, party cooperation, is probably key to making bifurcation work. Very often that just isn't the case in arbitration. Might lead to the tribunal having to be involved in weighing in on the terms of bifurcation, adding yet further costs and delay. And it might end up in an order that neither party really wants. So that's more of this to factor in.
I mean, I think it's fair to say there are pros and cons of bifurcation. Obviously, comes down to the circumstances of each particular case. But as Liz has said, it's certainly one tool that the parties and the tribunal need to bear in mind when thinking about time constraints and how to manage the hearing effectively. One final subtopic on this question is how to deal with post-hearing submissions. As Charlie raised earlier, should there be written post-hearing briefs? What about oral closing submissions? What is more effective? Liz, what are your views on that?
Well, I like them. Maybe I just need a bit of spoon feeding at the end of a long case. I find it really useful to have the facts drawn together for me. If it's just a case of construction of a finance agreement or an intercreditor agreement or something like that, you might not need them. Where you've had a lot of factual evidence, relevant factual evidence, I find it really helpful for counsel to do the hard work and to pull the references and the transcripts or in the documents together. Now, interestingly, some civil law arbitrators do not agree. I was in a Swiss arbitration conference in Turkey sometime last year, and I was very interested by a lot of the Swiss arbitrator and the Turkish arbitrator's views, which was no, the parties have given us these monumental memorials, these even more monumental opening submissions. We must go away and do the work. And I felt a bit humble about that. I felt maybe, you know, I as a judge, I've just been too spoon-fed and could click my fingers and ask for some post-hearing briefs. On the other hand, I do find that most counsel do like post-hearing submissions because it gives them an opportunity to go away, think about things, and actually put their case in a far more concise way, given how the case has developed over the course of the hearing. So I'm a great supporter of it.
Well, I am too, depending on the case. Where I find them unhelpful is where the parties who are exhausted at the end of what may be a very tightly compressed period of days when they'd be working on the case, then say, well, we actually want sort of 6 weeks, 8 weeks for the post-hearing brief. And before you know where you are, you're getting into a timetable of which there is such a gap between the hearing and the tribunal's receipt of the post-hearing briefs that you are, the tribunal is being asked to look at something that will then seem like ancient history, because most of the tribunals who we are lucky enough to appear in front of or to be part of are very busy. And the idea that those 6 weeks will be not spent by working on 4 different cases seems to me to be unrealistic. So what you have is a period of fraught activity during the hearing, followed by complete switch to something else, and then bang, in front of the tribunal, you get this very often very voluminous, the longer period given, in my experience, the longer the post-hearing briefs seem to be, and the word brief seems to be a sort of a cruel joke. Now that can be mediated. That can be the problem with that can be reduced by sort of maybe having oral closings immediately after the delivery of the post-hearing brief. But then you're getting another layer on top of it, and all of a sudden the hearing seems like a sort of warm-up act, and everything turns on the submission of the post-hearing brief and the oral closings if you've got them. So I'm in favour for the reasons that Liz gives. I think it's very helpful for a legal team to be able to direct the tribunal's attention to the key points. But I think the key word should in fact be brief, as brief as the circumstances allow. You've got to give the tribunal the references you want them to follow through and put into their awards, but to produce pages and pages and pages of stuff with large quotes from transcripts going through, it tends to mean there's this huge gap between hearing and post-hearing brief, and I think that's not to be wrong.
Can I just come in there to say that I've persuaded my co-arbitrators in an arbitration recently not to impose any pages on the post-hearing submissions. And my co-arbitrators said, oh no, we want something brief. So I said, no, let them take their time. They each put in 300 pages. I'm not a popular person. But I think I am with the parties, because hey, that's what we wanted to do, with no patience.
It's a really interesting topic, and as someone who's just put in a 150-page post-hearing brief, I have views on it as well. But we've run out of time, I'm afraid, for our panel discussion, a recurring theme this morning. I'm afraid everyone, it is 12 o'clock, and that is all we have time for. Perhaps we should have bifurcated this session. Thank you very much to the panel and to all of you for coming. Advocacy and arbitration is such an important topic. I really hope that this session has been of some use to you. Thank you.